Just as soon as I think I can get up from my desk, I get pulled right back in. Hey guys, this is Jules with True Crime Reactions. We have new documents again in the Idaho 4 case. Now, the video I did previous to this was the most recent documents up until that point, where we found out that the defense is filing a motion to stay the case. If that gets granted, it literally puts this entire situation on hold. The state seeking the death penalty and everything gets put on hold until further notice. Now today, as most of us expected, we have the state's response to the defense's request for the stay, and now we also have a compelling motion that was filed by the defense, and this is pretty specific. So I want to go over those details with you guys. We're going to go ahead and open the first one now. Okay, so we didn't go over these on this channel, but I did post them in my community tab. This is literally just the notice of the hearing that we talked about in the previous video. That's why I didn't talk about these documents, because it was basically just duplicates of stuff we've already seen. Now, the first one I'd like to go over actually is the amended motion to stay the proceedings. I have not gone over these. Now, I was in Dago's live at the very end of the day, right after I clocked out of work, whenever we found out that these had just released. We went over like one of the documents in the live, so I really don't know what any of this stuff says. I am getting it for the very first time at the same time that I'm doing this for you guys, so whatever y'all get reaction-wise is legit. I have no idea what any of this is talking about. But since it is an amended order, that's how I know that most of this stuff is going to most likely be all of the same. I guess we'll run through it real quick just in case there's something different. Let's see. Mr. Koberger indicted on May 16th by grand jury. He filed a motion to make available the record of all proceedings of the grand jury pursuant to ICR 6.2, and a motion requesting release of grand jury materials under qualified protective order. Okay. On May 19th. Yeah. The state then filed their state's response to defendant's motion regarding grand jury and transcript and a proposed order on May 30th of 2023. The parties are not able to reach agreement regarding the release of grand jury materials. Yeah, I mean, this is just a big, stupid back and forth fight, honestly. In further opposition of Mr. Koberger's motion for the preparation of grand jury records on June 6th of 2023, the state filed their state's supplemental response to defendant's motions regarding grand jury record and transcript. A hearing is scheduled on June 27th. Yeah, that's like the 20th time that we've been told that one. Mr. Koberger stood silent in his initial arraignment to preserve his right to contest the indictment. He also asserted his right to a speedy trial pursuant to the United States and Idaho constitutions. Jury trial is scheduled to begin October 2nd of 2023. Time is of the essence. Now, I know that that's what it's still claiming. But with all of these extensions already being approved by both sides, and the fact that both sides at this point, all this time later, have still not apparently gotten everything that they're asking for, because, I mean, the prosecution is asking for Brian Koberger's alibi, and the defense is asking for all of the grand jury materials. So it seems like both of them are really just dilly-dallying and trying to waste time and honestly just get as much money out of this case as they can. I know there's been a couple of channels talking about that lately, how the prosecution has asked for more money for handling this case. And honestly, for what? Like, if you really feel like you've got your guy and you're doing all this stuff after you've already arrested him, then you should be really, really sure. And you shouldn't need to do anything else. You should just give over what you've got and let's get this said and done. So there's just, it seems like every morning you get online and you just find out that there's just one more crazy thing happening in this case that just, yeah, you guys know what I mean. Argument. By the time this court hears arguments on the preparation of the grand jury proceedings, almost 6 weeks will have passed from the time of the indictment. Preparation of the grand jury record will then take additional time. Mr. Koberger has the right and intends to contest the indictment. Idaho Code 2-213 allows the defense to seek a stay of proceedings, and I'm not going to read this because it's literally the same as last time. Mr. Koberger seeks to stay the proceedings as appropriate relief while the matter of the grand jury record is argued and prepared. prepared. He is exercising due diligence to discover the grounds upon which to file a motion to dismiss related to how the grand jury was selected. He is being delayed through no fault of his own. Conclusion. Mr. Koberger's request to stay proceedings until the grand jury is prepared and he has adequate time to contest the indictment should be granted. The remedies allowed in Idaho Code 2-2133 are the exclusive means by which a person accused of a crime may challenge a grand jury on the ground that the jury was not selected in conformity with this chapter. A stay of proceedings is appropriate. Okay, so honestly, I'm a little confused because I didn't read anything brand new in this, at least not right off the top of my head. So let's actually go and look at the other one. Here's the motion to stay. I'm not going to go through with a fine tooth comb in this moment in time and try to see exactly why we have this one and now this amended one. But I will do it at some point this weekend. And if I actually find something different, I will post it in the community tab. But let's go ahead and go on to the next one. State's objection to the motion first and get the motion part out the way before we move over to the next subject in play. Okay, so yeah, this one is objection to motion to stay proceedings. This would be the state's response to the defense wanting to stay the proceedings until further notice. Comes now the state of Idaho by and through the Latell County prosecuting attorney and object. You know what? I think I can make this bigger. Oh, what? Okay. Oh, that's so much better. I'm learning, you guys. All right. Comes now the state of Idaho by and through the Latell County prosecuting attorney and objects to defendant's motion to stay proceedings. For the following reasons, defendant's motion should be denied. Background. On May 16, 2023, defendant was indicted by a Latell County grand jury of 4 counts of first-degree murder and 1 count of burglary. 3 days later, on May 19th, defendant filed a motion requesting release of grand jury materials under qualified protective order, motion to enlarge time to file pretrial motions, and motion to make available the record of all proceedings of the grand jury. On May 26th, the state filed its response to defendant's motion to enlarge time. The state noted that it did not object to defendant's motion to enlarge time and went a step further by concurring in his request for additional time. See, that's why I was kind of confused why we had a hearing on the 27th for that specific thing, because the same time that we got the motion hearing for the enlarged time, we also got the state's response to agree to it. So that was a little strange, but it seems like the one that's actually going to be happening on the 27th is for the motion to stay the case. I'm not 100%, but I'm pretty sure that's what I'm hearing. On May 30th, the state filed its response to defendant's motions regarding grand jury record and transcript and a proposed order for preparation and release of transcript and record of grand jury proceedings with conditions. As noted in that response, the state had also provided a proposed stipulation to defendant's counsel on May 25th. After the parties were unable to reach an agreement as to the scope of grand jury materials that would be subject to release, the state submitted its supplemental response to defendant's motions regarding grand jury record and transcript on June the 6th. On June 13th, the defendant filed a reply to state's supplemental response to defendant's motions regarding grand jury record and transcript, addressing the substantive legal arguments that state set forth on its June 6th supplemental response. Also on June 13th, the defendant filed a motion to stay proceedings. Defendant asserts that he intends to contest the indictment. Defo to stay, page 2. Oh, okay, so that's referring to the actual motion from the defense for the stay, page 2. That's what they're referring to with the statement about defendant asserts that he intends to contest the indictment, because that is what the intention of the defense is to do, and asks that this court to stay this matter so that he may discover the grounds upon which to file a motion to dismiss related to the how to grand jury was selected. What the shit did I just read? Let me do that one. I don't understand. Okay. And asks this court to stay this matter so he may. Bro, who wrote this? So that he may. Okay. This is making me feel like I'm stupid, but in reality, whoever wrote this is stupid, guys. It's not me, I promise. so that he may discover the grounds upon which to file a motion to dismiss related to the how the grand jury was selected. Related to the how the grand jury was selected. Guys, you see this. This is not me not knowing how to read. This is literally them not knowing how to type. Holy crap. Okay. In his motion to stay, defendant relies solely on Idaho Code 2-213. You know what? Let's take a second. I want to actually look this up just to have it in here. So let's go ahead and open it. Okay, so I wanted to see exactly the verbiage for this Idaho Code 2-213, and this is what this browser is telling me. Idaho Code 2-213 is a section of the Idaho statutes that deals with staying proceedings or quashing indictment for irregularity in selecting jury. So it is a code very specific to the grand jury selection. Okay. Argument. Defendant's reliance on Idaho Code 2-213 is misplaced. The statute provides that a party can request a stay in proceedings where there has been a substantial failure to comply with the applicable law in selecting the grand or trial jury. IC 2-2131. Under 2-213, a motion to stay must contain a sworn statement of facts which, if true, would constitute a substantial failure to comply with this chapter. Only after the court determines that a substantial failure to comply has occurred can the matter be stayed. And now they have this piece right here. Upon motion filed under subsection 1 of this section containing a sworn statement of facts which, if true, would constitute a substantial failure to comply with this chapter, the moving party, okay, this is basically the exact same thing. So what I'm getting from this is because there's nothing specific in a sworn statement in the motion to stay that was actually presented by the defense. They're claiming that that's the reason it should be denied. Okay. As the plain language of the statute makes clear, a moving party must make a factual showing of substantial failure to comply with the statute, and only after a court makes a finding at such failure to comply occurred can the court stay the matter. Defendant's motion is deficient because he did not include a sworn statement of facts, which, if true, would constitute a substantial failure to comply with this chapter. Rather than include a sworn statement with his motion, defendant asserts in a footnote that Mr. Kohberger will comply with filing a sworn statement of facts in accordance with IC 2-2132 as soon as he has the grand jury record. And this is where they refer to page 3 of their actual motion to stay from the defense. By including this promise to file a sworn statement in the future, defendant implicitly concedes that his motion is deficient at the present. Because defendant has failed to comply with this key requirement of Idaho Code 2-213, his motion should be denied. Defendant asks this court to put the cart before the horse. Stay the case now, and defendant will give the court a basis for the stay later. The court should decline to adopt this backward reading of the requirements of Idaho Code. Defendant's motion should be denied. It is ridiculous how smart-ass both these sides are to each other. I mean, it's funny, but it's also really just unnecessary. Essentially, Mr. Kohberger is asked to look at some but not all, and then ask for more at a later time. See, it's just a bunch of back and forth. It's stupid. Okay, so now we're going to go to the defendant's second motion to compel discovery. Come now, Brian C. Kohberger, by and through his attorney Ann C. Taylor, public defender, and pursuant to Idaho Criminal Rule 16F, hereby moves the court to order the state to comply with defendant's first and second supplemental requests for discovery and Exhibit A and Exhibit B attached to the request. Now, we saw before a few days ago that the state wants Exhibit A and B completely sealed, so I'm glad that this is being more specific. Okay. The state has provided a significant amount of discovery materials and has provided written responses to the discovery requests. However, certain requests remain outstanding. As such, Mr. Kohberger requests an order for the state to disclose the following items included in defendant's first and second supplemental request for discovery. Exhibits A and B. 1. Request 1. Investigative reports and conclusions from all cell phone analysis, including but not limited to any analysis conducted by police agencies, FBI CAST team, or other Idaho authorities. The state has responded by listing page numbers and audio video file names for information and data provided to the defense in discovery. As of June 13th, 2023, counsel for Mr. Kohberger has not yet received any investigative reports and conclusions of the analysis of this data conducted by police agencies. So this is stating that the state sent over page numbers and audio and video file names for certain data items, but that whenever it comes to the actual, I guess, conclusions really being written about the analysis that came out of looking at all of this data, they're not getting any of that. So basically, what they want is something that summarizes exactly everything that the police are using to prove that Brian Kohberger is guilty, and they want it all on a paper. They want it in black and white and in proof that this, and this that was found whenever we looked into this, and the third is the reason why now we believe this, and this is the conclusion. This is the summarization of our entire analysis of the cell phone records. The defense wants that, and the state is not giving it over. 2. Request 4. All footage provided to forensic examiners with FBI used to identify make and model of vehicle. A. All reports generated related to the identification of the white Elantra. B. All reports, communications, and documentation related to the change in year of the white Elantra sought. Okay, that's been one of the biggest things because they told us from the very beginning completely different years than what they ended up telling us later. And then those years didn't even really match up to the actual year, make, and model of the vehicle that Brian Kohberger ends up actually having. And we also need to keep something else in mind here. They have only provided us with stock photos of the vehicle they were looking for. Now, the gas station photo of a car, that was released by Brian Enton from News Nation. That was not released nor verified by any agency involved in this investigation at all as being the car or not being the car. That was only given to us by News Nation. Now, when it came to the actual vehicle being looked for, all the footage from security cameras and traffic cameras that they claim that they have in the PCA, and they couldn't release us one still shot of the car so we knew the actual vehicle that was being looked for. I always found that really a red flag here, that they have pages and pages of GPS and traffic cams and all this crap in the PCA, but they never released us even a little snippet of footage to show us the real vehicle. I have always found that extremely shady. And then C states CV or credentials of forensic examiners. The state has responded by listing various page numbers and file names of recordings they have previously provided. However, they do not provide any reports generated, communications, or documents relating to the change in year of the white Elantra or the CV or identity of the forensic examiner who identified this as the make and model of the vehicle. So not only do they want any of the reports that came with how they came up with the original year, make, and model, the one that they ended up changing it to, but they also want the information of the forensic examiner themselves. And this forensic examiner is mentioned in the PCA by both Blaker and Payne. So I don't know why they need to keep that part secret if he was somebody who was helping, he or she was somebody that was helping investigate the case. That should kind of be record for everyone who's involved in the case to see, in my opinion. I don't know why that would be something so secretive. And I don't understand why the defense wouldn't already have that. It's literally just about the car. But then again, we've had crazy stuff happening with the car in this case from the very beginning. Request 17. Please see Exhibit A to defendant's first supplemental discovery request for specifics. The state has responded that they are attempting to obtain this information. If it exists, the state will comply with this request upon receipt. And then we have request 23, which is the same thing. Please see Exhibit A to defendant's first supplemental discovery request for specifics. The state responded that they have provided AV 000123 discovered on 3/30 of 23. However, the provided recording is an in-person interview with FBI agents rather than a phone interview done by Moscow police. Hold up. Okay, I gotta go look. Okay, so both of these state, please see Exhibit A to defendant's first supplemental discovery request for the specifics of what this is talking about. But when you go to the defendant's first supplemental request for discovery, it's literally just 2 pages with no specifics. So I guess that's not for the public. I guess that's meant for the courts, and they're going to have all of those specifics. Yeah, I even went and pulled up the state's response to the first supplemental request for discovery, and it's nothingness. So does that mean that there was a phone interview done with Brian Kohberger in Moscow PD prior to him being their guy? Does this mean that this was an interview done with FBI agents after his arrest right here? But that what they're looking for, what the defense is looking for, is a phone interview that was done maybe with Brian Kohberger with the Moscow PD? My mind's turning now. That's interesting. Okay. Number 5. Request 109. Identity of FBI special agent that is a member of the cellular analysis survey team that was consulted with to determine locations of the cell phone from 11/12 and 11/13 and all cast certification records and training records for the involved agents. The state objected to this request for the reason that this was outside the scope of ICR 16. To the extent that the state intends to offer expert testimony, it will comply with ICR 16b7. Mr. Kohberger disagrees, as this information was largely relied upon in various warrants, including the arrest warrant. Yes, very valid point. Information relied upon to secure search and arrest warrants is necessary to conduct analysis of Fourth Amendment issues. It is about time they start putting the constitutional rights in this. Okay. Further, the entirety of the information could include materials required under Brady. Oh, look, there's that beautiful word again. Idaho Criminal Rule 16 covers broader area than the evidentiary rules of admissibility. Number 6. Request 120 and 140. All tips received by law enforcement relating to this case. The state has provided various tips throughout discovery. However, they are scattered in pieces throughout the discovery. A complete and chronological list of all tips has not been provided. And I've made this a point once I started this channel, I made this a point. They give us information scattered all over the place. They give us this timeline here, and then they'll give us something related to a whole entire different timeline that ends up being part of the original timeline, but we've gotten everything so out of order that we are unable to kind of pay attention to the way things are supposed to go. That's why whenever I went back and did my combining timelines thing, and how I've done most of this since we've started this Idaho case, is I've gone in and taken timelines for a certain section of time, but from every single source that we're getting it from. And then you put it all together. And it seems like that's exactly what the defense is asking for. They're wanting everything given to them in chronological order. And honestly, this would help them figure out just when exactly, if it was a tip that put them onto Brian, when the tip was actually received versus when it was worked upon and what was done in between. This is actually pretty important, honestly. But I believe there was like over 9,200 tips, right? Like well over 9,000 tips. That's going to be quite a bit, but the state should already have all that stuff in order. Honestly, there's like great AI programs and it's 2023. I don't understand why all of this would just be scattered about in pieces anyway. It's so easy to keep things organized these days. Number 7, request 136. All audio recordings relating to all search warrants obtained in this matter. The state has responded that they are attempting to obtain this information. If it exists, the state will comply with this request upon receipt. The defense has been provided with a photograph of a DVD entered into evidence as item 435 23M 0085, labeled as SW audio. There is also a notation that this DVD was copied to county on 1/13 of 23. What is SW? I don't know anyone off the top of my head whose first name starts with an S or whose last name starts with a W. So if you guys have any idea what the hell SW could possibly mean, drop it in the comments, please. Number 8, request 64. Body cam recordings, notes, photographs, and all information collected at the autopsies by Tollison, Vargas, and Gunnarsson. If I recall correctly, Gunnarsson was one of the first responding officers. And if I remember correctly, again, he's also somebody with a current Brady Giglio situation. If I remember right, I could be wrong. I am going off of memory. It is Friday. I am exhausted. My brain is tired. So if I'm wrong on that, forgive me and let me know in the comments. But I believe 90% that is correct. The state responded that they do not have these items in its possession. Clarification is needed on if they exist and are still in possession of another agency. Why wouldn't the state have the autopsy information whenever the state's the one who made sure that the autopsies were done? Now, I do know that in the PCAs, they list that there is an autopsy dated for Ethan on December the 15th by a coroner in Spokane, and not the original ditzy chick that we saw being the coroner in the beginning of this case. And I've questioned for a long time if there was second autopsies done by this Spokane coroner on all 4 of the victims or just on Ethan. But I still don't understand why the original autopsy documents wouldn't already be in the possession of the state. That stuff would have been done that makes no sense, but okay. Counsel requests that this motion be set for hearing in order to present oral argument, evidence, and or testimony in support thereof. And that is going to be the June 27th hearing date. Okay, we are on to our very last one. This one is the clarification to the state's supplemental response to defendants' motions regarding the grand jury record and transcript. Because remember, at this point, the state has not given over anything grand jury wise to the defense. And the defense wants to be able to put an appeal towards the indictment, but they can't fully do that until the state gives them all of the information and all of the information at once. They don't want the same little pieces and crumbles and bits and pieces of nothingness that it seems like the state has been handing over to them this entire time. Just the verbiage and what we've just read really does make it seem as if they're giving them information that is scattered, probably not on the exact same level of what they're looking for. It's not coming to them in order. It's not coming to them with any clarifications. It's not coming to them with any conclusions. They're just being sent stuff. So it's at this point, it's almost like, how does the state even know what they're doing if they're not giving the defense over anything that looks like they know what they're doing? If it's all in bits and pieces and the defense is having a lot of questions about what the hell they're even looking at and why they're looking at it, that's a problem. The defendant's reply to state's supplemental response to defendant's motions regarding grand jury record and transcript dated June 13th, 2023, suggests that the defense believes the state wishes to limit the transcript/record to the evidentiary presentations and list of grand juror notes. Note: at the bottom of the first page of the defendant's above referenced reply, the defense refers to the grand juror notes. Although this is likely a typographical error, the state wishes to note that the individual notes of the jurors are not available for inspection by any party. Okay. For any of you that have been on a jury of any type, what did you do with the notes that you took while you were in deliberations? While you were sitting there listening to everything that was given to you, were you allowed to like actually write down stuff on a notebook pad and actually take notes? Was there some sort of tablet that you had? What was it like? What kind of notes did you take? What kind of processes were put into place for whenever everything was over and it was time for you to do something with those notes? Because it seems to me, just by reading this, that if the jurors' notes are not available for inspection by any party, that means that they're probably not kept for any reason. So, do you guys get to take those home or do they have to be thrown away before you get to leave? If anyone has answers to that from actual personal experience, please let me know in the comments because I am actually curious. To clarify, it is the state's position that the record transcript of the grand jury proceeding include everything that was done on the record and recorded by the clerk and or court reporter, including the jury selection process. We're in a situation where the grand jury was a standing grand jury that was not impaneled specifically for this case. The state would likely have a different position. However, because this grand jury was impaneled specifically for this case at bar, the state believes that the transcript record should include the jury selection process. Okay, this is actually important because we were basically told way before the grand jury happened that it was going to happen and when it was going to happen. And I did a video on this. I'm going to have to go back and see if I can find it. I might not have time before I get this video out, but I know that we watched a clip and went over it where a woman came out and was talking about the possibility of a secret grand jury happening. And in this report, she said if it's going to happen in May. And we also know from the Gonsalves family's attorney and some things that Steve has said that they knew that there was going to be a grand jury getting together, but they weren't told specifically that it was going to be about this case. They just had an idea that it probably would be because of the serious magnitude of this case. So it wasn't just a regular standing grand jury that gets called for whenever they have just a regular grand jury thing where they can call anyone in. They're claiming that this jury was selected specifically for this quadruple homicide case. And that could actually be, or it is actually, extremely, extremely important because if it's not a regular standing grand jury and it was specifically impaneled, that means that the selection process would be different than for a regular standing grand jury. And honestly, yeah, the defense has every right to know exactly how that process went. In essence, the state's position is that the transcript record begins with the assigned judge first goes on the record and continues for all reported recorded events through the discharge of the grand jury. The state respectfully submits that this addresses the defendant's interest in the questioning of prospective jurors as well as the nature and quality of evidence presented, including whether exculpatory evidence was included as described by the defense in the first full paragraph on page 3 of their reply. Okay, well, like I kind of understand the point that on the record and full transcript is from the beginning of the actual grand jury proceeding with, gravel, woohoo, court in session, and then all the way to the end. But they're making it clear, like we just said, this grand jury was impaneled specifically for this case. Therefore, I think they have the right to know the process, especially since this has been such a widely covered case. And again, leads back to the mainstream media gag order. So there we go. Full circle again and more questions. But that is it, you guys. That is all of the documents that were dropped today. It is almost midnight, so you guys might be getting this a little bit late. I do apologize. On Fridays, I do try to do a lot of stuff with my kids, but I knew that I needed to get these documents out as soon as I possibly could. Now, out of everything that we learned here, besides the fact that the state seems to be massively unorganized, there is a very strange SW audio that I'm curious about, and it seems like the defense is very much under the impression that there is an interview that was done by Moscow PD that they very much need to get their hands on. Now, I know I couldn't find anything in the first supplemental response documents that were mentioned when it came to this information about this interview, but I do recall there being documentation where an interview that was done was being requested. And if I do recall correctly, it had to do with Detective Payne. Now, if you guys remember this, please leave it in the comments and let me know if I'm remembering this correctly. But I would really love to know if there was an interview done. A lot of people are questioning how it went from there literally being no one specifically that the cops and anybody was looking at to all of a sudden they're following someone all the way across the country and making an arrest. So if there was actually an interview that was done, it would have had to have been after November 29th, whenever we know that his car data was pulled from a security officer at WSU a little after midnight, and then about 30 minutes later, a completely separate officer saw the vehicle actually parked in the Steptoe apartment parking lot. So I would assume that this interview would have taken place sometime between November 29th and December 23rd is whenever they actually pulled his personal phone records, but he was out of town by, what was it, like the 12th? Around the 12th, 13th? So they really wouldn't have had but maybe a 2-week window after getting the information from the car database at WSU before he left town. I wonder if the date of that interview is going to be somewhere in there. If it is an interview with Brian, it's going to be interesting to get the details from this. But like I mentioned, that is it. And I want to know what you guys think about this new information in the comments. See y'all.